I received a phone call today from someone asking me if I believed the DA staffer who was charged with that child endangerment could receive ARD. And like I tell a lot of people, there's a lot of cases where a person can receive ARD even for a serious charge like that. It's really a case-by-case basis. And, if she were to receive ARD, I'm sure a lot of people would believe that she's getting some type of special treatment. But to be upfront with everyone, there's a lot of cases where a person receives ARD, and these individuals don't know anybody. It's just that their attorneys are able to negotiate that type of resolution for their clients, and that's really just a great job on the part of the attorney to do that. Even though people will sometimes assume that ARD is all the prosecutor's office, and it's whether or not it's their discretion to grant ARD. That's true to some extent, but it's still on the criminal defense lawyer to talk to in this case, the AG's office about it. Again, we don't know for sure that she's getting that, but if the case were to result in that, I wouldn't be totally shocked. But that being said, obviously she's charged with a felony. She's scheduled for a preliminary hearing. I would imagine that if ARD was potential on the table, she'd have to waive that preliminary hearing in order to be considered for it. That's usually a very standard condition in order to be considered for ARD. I would not waive that preliminary hearing unless I had something in writing from the prosecuting attorney stating that either she'd be approved for ARD or that the prosecutor's office would support an ARD application of some sort, but something in writing. I would not go off of a verbal, just a verbal yes or no from the prosecuting attorney. Not that I don't believe anybody, it's just that in my experience, prosecuting attorneys change very frequently and things get lost in translation. It's always better to have it in writing. With that said, obviously she's charged with the felony offense more so, I believe, because of the child's age, not necessarily because of the danger the child was put in. I'm not obviously condoning what happened. I think it was bad judgment on her part, but it's my understanding that the child, based on what I've read, wasn't in any immediate danger to satisfy necessarily enough of the elements of that offense beyond a reasonable doubt. But obviously the age, there isn't an issue there. And as I stated in a previous video, a child endangerment is normally a misdemeanor charge if it's simply the parent or the guardian or the caretaker violating a duty of care. It escalates to the felony charge for one of two reasons: either the parent or caregiver created a substantial risk of death or bodily injury to the child, or the child is under the age of 6. In this situation, the child is 4. So I believe that's what they're going under in terms of the subsection statute. So again, every case is different. I would not be surprised if the case resulted that way, but I think people need to kind of consider the other things in the case, the fact that she has no prior criminal history, that's important. And while people can always state, well, what if this and what if that? And again, I'm not condoning anything, but I've heard that argument made by prosecuting attorneys very often in DUI cases, that what if a person was on the road, or what if a young child was crossing the street when this person was drunk, the person could have been killed. And I understand the argument, but that didn't happen. So while we can talk, to some extent, you can take any criminal offense, even a minor one like speeding, and use it to kind of blow it up and say, well, if you were speeding, you could have killed someone. Well, again, those, in my experience, aren't the best arguments to make. So if you have questions about a criminal case or a criminal charge, or whether or not you qualify for a diversion program like ARD or PTI in New Jersey or a Section 17 in Pennsylvania, please give us a call at 215-755-9000. We answer that phone 24 hours a day, 7 days a week. You may also text us through our website at gambonelaw.com. You have the ability to text us now through the website. It's a great feature. On the website, you're going to find my podcast, my books, all of my blog articles. It's a great resource if you're facing a criminal charge. I hope you're all doing well this afternoon, and I'll talk to you soon.